From 14 to 18 February 2022, the Appeals Chamber of the International Criminal Court, composed of Presiding Judge Luz del Carmen Ibáñez Carranza, Judge Piotr Hofmański, Judge Solomy Bossa, Judge Reine Alapini-Gansou, and Judge Gocha Lordkipanidze, held a hearing in the case the prosecutor v. Dominic Ongwen to address the defense's grounds of appeal relating to Mr. Ongwen's conviction and sentence. A year ago, on 4 February 2021, Trial Chamber 9 found Dominic Ongwen guilty of a total of 61 crimes, comprising crimes against humanity and war crimes committed in northern Uganda between 1 July 2002 and 31 December 2005. 2 months later, on 6 May 2021, Trial Chamber sentenced Dominic Ongwen to 25 years of imprisonment. The defense raises 90 grounds of appeal consisting of alleged legal, factual, and procedural errors relating to the conviction, and 11 grounds of appeal alleging legal, factual, and procedural errors relating to the sentence. Mr. Crispus Ayena Odongo, lead counsel for Dominic Ongwen, in his remarks, asked the judges not to punish Mr. Ongwen for the second time, referring to the fact that his client was abducted at the age of 9.
My lords, the appeal before you is about a child who was brought up under very mean circumstances. A child who, as a result of human trafficking, was abducted at the age of about 9 years because the government of Uganda, who shamelessly preferred the charges against him before this court, and the international community, which created the court that tried him, as well as this one, failed to protect him against Joseph Kony and his LRA. A child who was not rescued by the same government of Uganda and the international community from the armed conflict between the government of Uganda and the LRA. A child the government of Uganda and the international community failed to rescue from the evil grips of LRA for close to 25 years under enslavement, doing forced labor for LRA. Your Honors, Madam President and Your Honors, even at the time of the charges against him, Dominic Ongwen was and still is a child, because the spirits of Joseph Kony, in which he verily believed, possessed him, and he has not undergone any cleansing rituals required by his culture to become free of those spirits.
Ms. Helen Brady, Senior Appeals Counsel at the Office of the Prosecutor, emphasized the position of the prosecution that Dominic Ongwen was fairly convicted.
Your Honours, Dominic Ongwen was properly and fairly convicted of 61 crimes amounting to war crimes and crimes against humanity after a trial lasting more than 3 years, in which the trial chamber considered evidence from 179 witnesses, both from the prosecution and the defence, and more than 5,000 other items of evidence. Dominic Ongwen's crimes occurred over a period of some 3.5 years and included a large number of grave crimes committed on a discriminatory basis against civilians during 4 separate attacks against camps of internally displaced persons, sexual and gender-based crimes committed directly by him and by members of the senior brigade, and child soldier crimes. These crimes included attacks against civilians, murder, rape, sexual slavery, enslavement, forced marriage as an inhumane act, forced pregnancy, torture, pillaging, and destruction of property. More than 130 people were killed during the LRA attacks on IDP camps. Hundreds of people were abducted, tortured, and enslaved during those attacks, and houses were looted and property destroyed. A large number of children were abducted, brutally integrated into the senior brigade, and used actively to participate in the hostilities. As a senior commander in the Lord's Resistance Army Senior Brigade, Dominic Ongwen played a key role in these crimes, planning them, organising them, and issuing orders.
Legal representatives of victims Francisco Cox and Paulina Macida submitted that the conviction and the sentence should be upheld in their entirety and conveyed the expectations of the victims in this case.
On behalf of the victims that we represent, we submit to the trial that the trial chamber was correct in finding and conclusion on each crime to find Dominic Ongwen guilty. Your Honor, I must contradict my distinguished and learned friend from the defense. It seems that everybody that approaches this case from the abstract raises the issue of Dominic Ongwen being a child soldier. And like I say, in the abstract, this makes sense. It is when you see the evidence that you disregard this approach. Mr. Dominic Ongwen, when he committed the crimes, was not a child soldier. As one of our clients said to us when we met them, yes, he was abducted, but it seemed he loved his job so much.
Madam President, Your Honors, this appeal is not about a child abducted at a young age by the LRA, injured and manipulated to the point of losing understanding and perspective of what was wrong and right, or put under such fear of death for himself or his loved ones that he did not have any other choice than to commit, in the most cruel ways, the 61 crimes he has been convicted for, both in the privacy of his home and in the bush, and in front of his soldiers during the 3 long years covered by the charges. If it were, these proceedings would not be occurring before this court today. It is not disputed that Mr. Ongwen might have been a victim of one or several crimes when he was a minor. However, this fact alone does not constitute a legal basis for excluding criminal liability under the Rome Statute. The fact that Mr. Ongwen had been abducted at a young age does not absolve him from criminal liability for the acts and conducts he committed as an adult.
A number of amici curiae were also given opportunity to participate in the hearing and provide their observations. While they are not party to the case, they were permitted to provide expertise and insights that have a bearing on the issues in this case. The decision on whether to consider an amicus brief lies within the discretion of the court. Upon the conclusion of legal discussion, the floor was given to Mr. Ongwen to address the judges of the appeals chamber.
I was a prisoner. I know that I'm a prisoner for life, because even if I served the 25-year sentence that has been imposed, I would have been in prison for the whole of my life. If you accepted evidence from the witnesses, why are you still going ahead to imprison me? What all the witnesses in this proceeding said, that the problems that people encountered in the LRA was extreme. Once you're a member of the LRA, it's equivalent to being a prisoner.
After Ongwen's address, the presiding judge closed the hearing. The purpose of this hearing was for the appeals chamber to hear submissions and observations on the issues arising in the defense appeals of the conviction and sentence. The chamber will make its judgment on these appeals in due course.